case, and therefore can be submitted to the Court of Appeals as part of the record on appeal. There's nothing in those rules or any rules of Superior Court that would require the submission of transcripts from prior proceedings to a new judge, a judge that's assigned to a separate hearing in the same matter, and to do so would establish kind of an absurd result in which at every stage of every proceeding in Superior Court, litigants would be required to submit transcripts of every previous proceeding in order for the court to consider them or to have them preserved for the record on appeal. That's simply not the case. It's simply not the state of the law or the state of the rules as the Court of Appeals addresses them. This case is assigned to a court. It's not assigned to a specific judge. These proceedings were in the Superior Court in the same venue, and the way judges are assigned, a different judge heard a different matter in a different hearing in the same matter in the same proceedings. And so this is a series of proceedings in the same matter. These transcripts are properly submitted as part of the record on appeal. They were referenced in both the defendant's brief to the court. They were referenced, the testimony from these hearings was referenced in the oral arguments of both the defendant and of the plaintiff in this matter. So the substance of what's in those transcripts is certainly part of the record. It was submitted to the court for their consideration. The Johnson case has no relevance to this hearing and the determination of whether or not to submit whether these transcripts from these preliminary hearings can be submitted as part of the record on appeal. In Johnson, the plaintiff in that case sought to submit transcripts from a completely unrelated case. It was in a completely different venue. It was a case before the Employment Security Commission. He subsequently brought a separate matter before the Superior Court, appealed from Superior Court, and then sought in his appeal to include testimonial transcripts from this Employment Security case, which was completely unrelated. And so I don't think that what the defendant cites in that case has any relevance to your determination as to whether or not these matters should be submitted as part of the record on appeal. I simply just don't think there's any presidential value. I think if you look at any substance, any support in the rules of appellate procedure that support this proposition, transcripts are treated very differently than exhibits. There's nothing in those rules that requires transcripts to be submitted as evidence. And so therefore, I don't think, I believe in settling this record, these transcripts should be included in the record of appeal. And that's the position of the plaintiff in this matter.
All right, counsel, if the court were to sustain the objection and not allow those transcripts to be included, they could still be included in a supplement to the printed record on appeal. Is that correct? Is that your understanding as well?
I do believe there is a mechanism for them to be included, but yeah.
All right.
Your Honor, if I may, I don't believe that's correct. My understanding of the supplement is that they are, if there's an objection under Rule 11C, then you simply include it for anything that has been submitted to the court. If you object and say an objection is based on it not being submitted to the trial court, then it's not included. And
again, I think that goes to the defendant's desire to treat these as exhibits rather than as transcripts of proceedings, which again, they're not the same thing, and the rules don't treat them the same way. They treat transcripts repeatedly throughout the rules of appellate procedure very differently than they do exhibits. And so I do think that's the heart of this argument.
So, counsel, it's not your contention that the transcripts were submitted to the court. I presume that they were in existence at the time of this hearing, because counsel for the defendant did submit excerpts to the court. I want to make sure I'm understanding your position. It is not your position that you did in fact submit the entire transcripts to the court for consideration.
No, I don't think it was necessary to submit them. And as to the defendant's contention that they were submitted to the court, I have no record that those transcripts were submitted. They were not attached as exhibits to the brief that was filed and served on the plaintiff. and they were not referenced or admitted into evidence at trial. So he may have submitted them. If so, I'm not aware that that was actually done.
All right,
Yeah, I'll be glad to address that if you like.
I'll hear from you.
That particular excerpts were filed in the court file. They were served on the secretary prior to the hearing. So they were, just like many of the other exhibits, they were in the court file, and then they were referenced in the oral argument. So they were clearly before the court.
Now, with respect to the actual order that was entered by this court, there's language in the order that specifically says the court, after considering only the pleadings of record and briefs and arguments of counsel, has determined, clearly indicating that what the court considered in ruling on this motion to dismiss. Is this about the relevance of these transcripts? Is that the argument that you're making, counsel, for the defendant?
Well, the argument I am actually making is that they were never submitted. If it only goes to the relevance, I believe in that case, then they are included in the Rule 11C supplement. If the court would decide that it's only a relevance matter. Anything that you object to is not being proper, but that was actually filed can go into a supplement, and then there is no further argument. You already make that argument in your briefs in front of the Court of Appeals. If it was never submitted to the trial court, then the issue is, well, the appellate court shouldn't be deciding a matter or shouldn't be deciding any case based on matters that were not submitted to the trial court because you never had the opportunity to consider them.
All right. And counsel for the appellant, I want to hear your argument on that. I mean, it seems if the material were not submitted to the court and considered by this court in ruling on it, how, if there is relevant information in those hearings and not being the judge that was assigned to hear that motion, how, if it's not filed as a transcript in a subsequent hearing like this in front of a different judge, how is a judge in my position in that situation supposed to know what was said and what testimony was offered at that prior hearing? Now, obviously, the orders that result from that hearing are a matter of record in the file, but any other evidence, witnesses' testimony and things in those prior hearings, how is the court in my position supposed to know what's in there in that situation?
Well, two things. I do think that they are, I understand your point, but I do think they are available to the court. Again, the way courts are administered in North Carolina is sometimes a bit strange, but I think these are transcripts from the court, not transcripts specific to the sitting judge on that specific day. But more importantly, I think that if we're getting into relevance, that's not an issue that's properly determined on this motion to settle the record. I think the relevance of those transcripts, it would be determined by the Court of Appeals. I think the only question here is whether, I think as the defendants have raised, the only question here is whether they were submitted into evidence at the trial court, and therefore, if they weren't submitted, they can't be included on the record on appeal. And I just don't think there's any support for that position. Whether they're relevant or not is not germane to the determination of whether or not they're included on the record of appeal. I think that is something that the Court of Appeals can make a determination at the appellate level as to whether or not any contents of those transcripts are relevant. And again, I would dispute that they're irrelevant in that the testimony from those hearings was referenced multiple times by both parties and included in the brief submitted by the defendants. The defendants submitted selections from that transcript, but the Court of Appeals, that selections from that transcript may be insufficient for the Court of Appeals review. They may want to see the full context of the testimony. And frankly, that's not, again, before the court today to go into the details of what is and is not included in that selection of transcripts. That would be for the Court of Appeals to review and determine, whether what's in those transcripts is accurate, or what's cited to in that brief accurately reflects what was testified to in those hearings. So that's our position on that matter.
All right. Anyone else wish to be heard further?
No, sir.
All right. In this case, I'm going to find, and the court is not ruling on relevance, as indicated, that's not proper for this court to rule on whether or not those transcripts are relevant. The court is going to make a finding that the entire transcripts were not submitted to this court, were not considered by this court at that hearing on the motion to dismiss. Because they were not submitted, they are not to be included in the record on appeal. However, I will order that it is allowed to be placed as under Rule 11C as a supplement to the printed record on appeal, may be provided to the Court of Appeals in that method. All right. And counsel for the plaintiff, if you will, please draw up that order and submit that to me. You can submit it to Ms. Boger electronically and make a copy available at the same time that you submit that to opposing counsel, and then that can be forwarded to me for signing.
Yes, sir.
All right.
Thank you.
Thank you. Anything further?
No, Your Honor.
All right. And we will adjourn this session. Thank you all.